Lachowski i Piątkowski o prawie międzynarodowym. Podcast Wydziału Prawa i Administracji Uniwersytetu Łódzkiego oraz portalu Obserwator Międzynarodowy.
Szanowni Państwo, drodzy słuchacze, serdecznie Państwa zapraszamy do wysłuchania naszego specjalnego odcinka. Naszym gościem jest dr Alexander Wentker, z którym będziemy rozmawiali o bardzo ważnym zagadnieniu, jakim jest kwestia uznania Polski jako strony międzynarodowego konfliktu zbrojnego podczas trwającej rosyjskiej agresji przeciwko Ukrainie. Odcinek ten nagrywamy w języku angielskim i niezmiennie prowadzimy go wspólnie z Tomaszem Lachowskim. Serdecznie zapraszamy Państwa do jego wysłuchania. So, good morning, dear listeners. Hello. This is actually our first full recording in English. We already have in the past one episode, but this is, I guess, a very, very special one. Our guest today is Dr. Alexander Wentker, Max Planck Institute for Comparative Public Law and International Law, Chatham House, author of book Party Status to Armed Conflict in International Law, published by Oxford University Press. Thank you very much, Doctor, that you were with us today.
It's a pleasure. Thanks for having me.
Thank you very much. And as usually, Tomek Lachowski is with me. And Tomek, I guess I will give you a floor to discuss the topic, this pivotal question, are we at war? I guess we are constantly circulating around the topic is very active in the public discussion here in Poland, especially. Where is the line between peace and armed conflict? Where is the line between the neutrality and belligerence? And yes, I'm giving a floor to you right now.
Thank you very much, Mateusz. Yes, indeed. There is a huge discussion in the political scene in Poland, also in the region of Central and Eastern Europe. This question where if we are at war is very, very dynamic also because of this situation that is changing also on the front line in the diplomatic different cabinets. And also we have to remind that especially in the last couple of weeks, those declarations that the Russian aggression against Ukraine in the language of international humanitarian law and the international armed conflict on the territory of Ukraine between Russia and Ukraine is turning into the World War III. Actually, those words were issued also by Mr. President Vladimir Putin, who recently talked about the changes in the conflict that is being more and more global because of the decisions of the Western states that we are going to discuss later on in this episode. Alexander, you are the author of a book titled Party Status to Armed Conflict in International Law. And actually, as I just mentioned, politicians have this kind of privilege to declare and announce many things like those that we are in the time of the World War III. But actually, how would this politicized statements correspond with the question of party status or co-belligerency in international law? How the third state, which is not directly involved in the armed conflict, like we are discussing the Russian-Ukrainian war, can become a co-belligerent in already existing armed conflict like this witnessed on the Ukrainian soil.
Yeah, so as you say, the notion of states becoming a party to the war in Ukraine is omnipresent in political discourse. And it's also actually omnipresent as a notion, that notion of party to the conflict in international law, particularly in international humanitarian law. But the difficulty from a legal perspective is that there is no set definition in any specific treaty that would tell us what makes states parties to an armed conflict. And now I use the term party to an armed conflict because that is the term that international treaty law today predominantly uses. There are some references in treaty law to co-belligerency still, but I would say it's arguably more consistent to speak of parties, although in essence, of course, what we mean by parties today is what under traditional international law would have been belligerents. But that's just sort of as a terminological notion. So as I said, the difficulty is we know that the parties are crucial for how international law regulates armed conflict. And we know that there is the possibility for multiple states to be parties to the same armed conflict, for multiple non-state armed groups to be parties to the same non-international armed conflict. So we know that that situation can exist as a matter of international law. We don't know how to get there. There's no specific treaty rule. There's probably also not enough practice and opinion juris for a specific customary international law rule either. So what we have to do methodologically, I think, is to arrive at criteria by way of systemic reasoning, deduction, if you will. And this is what I've tried to do in my book, to come up with an analytical framework for how international law identifies or helps us identify who the parties to an armed conflict are. And what I then did was to sort of confirm these results that I reached deductively, inductively by looking at that bit of state practice and opinion juris that we have. But I'm happy to talk more about the method, if you will, later. To answer your actual question on where is that line, what are the legal criteria that we can derive, what makes a state a party to an existing armed conflict? Well, here I'd say, in a nutshell, there are two essential criteria plus one specification. So assuming that the armed conflict, an international, non-international armed conflict already exists, what we need is a direct connection to hostilities. So that means causing harm to the adversary, military harm. Now, why is that important? Well, because hostilities are the building blocks of the conflict relationship between the parties. And hostilities can be defined as harm to the adversary or acts that cause harm to the adversary. So it makes sense to require that there is a direct relationship to harm to the adversary for a state to become a party to an armed conflict. And state practice actually also testifies to that. And there is reference to a certain sense of directness in that connection. Now, in practice, the question will be, what is a sufficiently direct connection to hostilities? And there, I think one helpful way to understand this is in line with how the ICRC understands direct participation in hostilities. And there the ICRC has suggested essentially that it's sufficiently direct if it's just one causal step to the harm. And I think we'll discuss practical examples later to make that more tangible. So that's the first criterion that concerns the nature of the acts that you must perform. The second criterion is related to the relationship between multiple parties on the same side. So what you need in addition is a close coordination with the other party or parties on the same side. That's the second criterion. Why is that necessary? Well, because it's not enough to simply fight in parallel. It's totally conceivable that one and the same state is fighting multiple armed conflicts with different other states at the same time. So what makes you a party to an existing armed conflict is that your acts build on those of your fellow potential co-parties so that they form part of the same armed conflict. Again, the difficulty will be to establish what is sort of sufficiently close coordination. And here I think a helpful way is to think of it in terms of having an influence on the decision-making processes, because international law actually assumes that parties are those that determine how military operations are conducted. And so the decision-making process, I think, is key to understanding this. Again, happy to specify later on. And then inherent in these two criteria, direct connection to hostilities and close coordination, inherent in that is that states must know what they're doing. So there is an inherent subjective element. They don't need to intend the legal consequences. They don't need to want to become a party, but they must know that their acts have that direct connection and are closely coordinated with others. Okay, so that's the concept of how you become a party in a nutshell. And I would say that these are, or I argue in my book, that these criteria actually form part of the general legal framework for identifying parties, both in international and non-international armed conflicts.
Thank you very much. So I guess what you just mentioned, that there need to be some kind of direct harm to the other belligerent, is one thing. And what I noted, you refer to the direct participation in hostilities, that there is somehow some kind of link, that maybe a hint that could guide us into to answer whether the specific action has this reach this threshold of harm, because I believe that was a part of the whole discussion regarding the direct participation on the hostilities. And the second question you mentioned is about cooperation. I think this is an elusive one, because cooperation requires some extra knowledge, and usually this might be somehow not very accessible, especially during the time of the armed conflict. But I think we could move to another aspect, because especially from Polish perspective, what is really interesting is a question of neutrality. And I kind of think that we could somehow find a link between this direct participation of hostilities and question of neutrality, or rather whether if one state violates the neutrality, whether of course we consider neutrality relevant, but I guess that's for another discussion. Whether mere breach of neutrality means that, okay, one state is violating the neutrality regime, and by transferring the weapon is already causing harm to the, other belligerent. So we this is interesting aspects. Of course, the position of the Western countries and Poland is that no, mere violation of neutrality regime does not make Poland, United States, Great Britain, Germany, France as a belligerent in the war. So we would love to hear your opinion in this regard. Do you agree with the official statements of the NATO countries that transferring weapons is not tantamount, is not equal to the participation as a party to the armed conflict on the Ukrainian side? But what about a little bit, let's say, complicated situation when, for instance, Ukrainian aviation is using Polish airspace, for instance, for the combat military operation? One interesting remark in this, at the beginning of the war, it was actually revealed just very recently. Polish High Command of the Polish Armed Forces, he said that on the night on 25 February, he get a call at 3 a.m. from Ukrainian military authorities that 3 Ukrainian military aircrafts, but actually they were transport planes, Ilyushins, are asking for a permission to enter Polish airspace. And he said that was a serious decision, because he believed that at the time those aircrafts are tracked and even targeted by the Russians. And ultimately he said, okay, we gave green light for the Ukrainian to land in Poland, and those aircrafts landed safely. But would such an action render Poland as a belligerent? And there's, of course, a lot of things to discuss in this regard. But what about the situation in Belarus in the light of using the airspace or using military bases, especially the air bases, as a platform to launch a sustainable combat military operation. So to summarize my question, let's start the question about the neutrality. So whether breaching neutrality regime means that we are a party or it's actually the opposite.
Yeah, I mean, great questions. Again, to begin with, perhaps to just sort of put this into context for those listeners who are not experts on the law of neutrality. So there is this idea in traditional international law that neutral states have certain obligations. Neutrals were basically all those that were not parties to a specific war. The idea was sort of that you had the belligerents fighting as sort of duelists, if you will, and other states had to keep out. That was sort of the basic idea of neutrality. You had to keep out, but that also meant that you were to some extent protected from the scourge of war. And so a traditional set of obligations for neutral states was not to support militarily the belligerents. And that, of course, if you consider it applicable to current international armed conflicts, would potentially complicate matters for states. Now, there's a lot of questions surrounding neutrality, one of them being, is neutrality actually still alive? And that probably would be a topic large enough for a whole separate episode. I think there is some evidence, in a nutshell, there is some evidence that neutrality is still alive. It's rarely at the forefront of international practice, but states do refer to it occasionally. States even refer to it in their positions on how international law applies to cyberspace. A couple of states do. So all in all, there is some practice that suggests that neutrality law is still alive. I think neutrality law can be made compatible with the current system of international peace and security law, particularly the UN Charter, if neutrality law is read and understood in light of today's jus ad bellum. But we can basically, in a sense, leave all that aside. So I think, again, there is room for arguing that neutrality law may still matter. But at any rate, I don't think that Western states would be violating their obligations under neutrality law, for one thing. And even if they were, it wouldn't be because that they are violating neutrality obligations in this case, that this would make them a party to the war. Now, I don't think that they're violating neutrality law obligations because I don't think neutrality law should and could today be understood as prohibiting states from providing military assistance to the victim of an act of aggression, and specifically the victim of an armed attack, because neutrality law should and could not be understood as making the right to self-defense ineffective. But again, at any rate, the violation of neutrality obligations is something different than becoming a party to an armed conflict. It's a distinct violation of international law that, under the law of neutrality, actually had its own enforcement mechanisms. Belligerent states were, for example, allowed to enforce the law of neutrality regarding a delinquent neutral, all of which suggests that actually you remained neutral even if you violated your neutrality obligations. So becoming a party is subject to different legal criteria, and specifically those legal criteria, I think, that I have suggested earlier, the two criteria I proposed. And now if we apply those criteria, looking concretely at the scenarios regarding the war in Ukraine that you alluded to, I think I'm inclined to agree that weapons and supplying weapons actually cannot make you a party to an armed conflict. That is because it would already not fulfill the first of the two criteria that I mentioned. there would not be a direct connection to hostilities because it is not the supply of the weapon that actually causes harm, but only the eventual use by the recipient of the weapon that causes military harm directly. So weapons, I don't see how they would make you a party. Territory is a more complicated case because I think it depends on the scenario that we're looking at. The Polish scenario that we refer to is one where Poland received, I think you said, transport aircraft on its territory. Is that right? So to me, it doesn't sound like what Poland did here was sort of taking part in a concrete military operation causing harm directly to Russia. If it were, it could have made it a party. I think actually the Belarusian example is a better one, and one that sort of might actually more closely bring you to the threshold of party status. Because if you allow your territory to be used as a launch pad for a specific military operation and active hostility that causes harm directly to the opponent, then that I think might actually have a sufficiently direct connection to hostilities. And this seems to have been the case regarding Belarus, right? Russia launched significant parts of its military operations against Ukraine directly from Belarusian territory. And then the question would be, is the second criterion also fulfilled? Do we have sufficiently close coordination with the military operations of Russia? And there, as you said, it's a question of knowing the facts of how different states interacted, and we simply don't know enough regarding the interactions between Belarus and Russia. Usually, you would assume that a state has a certain degree of coordination and a certain degree of a say in the decision-making processes on military operations that are being launched from its territory. But of course, the specific situation between Russia and Belarus may be such that actually Belarus has no say whatsoever. So we don't know for sure, but there is reasonable ground to believe that Belarus has become a party, at least for a certain period of time, by virtue of its acts. I think it's far less likely regarding the way that Polish territory has been used, because I don't think it has been used as a direct launchpad for specific military operations.
Thanks a lot for your comments. Actually, this issue of neutrality was also discussed in our episodes earlier with our guests and other experts. This interrelation between jus ad bellum and jus in bello is very, very interesting. At the same time, also very, I would say, hot issue right now because of the war in Ukraine. However, let's make this question even more complicated, because in the recent weeks, just after the losing of Kamala Harris in the presidential election against Donald Trump, Joe Biden decided to lift the restrictions on the use of the long-range weapons for Ukrainians to strike targets inside the Russian Federation, because before those long-range weapons were used because of the US decision only within the internationally recognized territory of Ukraine. So, for instance, against the military objects in Crimea or in the eastern occupied parts of Ukraine. This situation, of course, as a consequence, it made the rapid response of the Russian authorities, including Vladimir Putin himself. He said that actually those ATACMS attacks are right now supervised and directed by the US satellites and other transferring states like Great Britain or France. And because of that, because of this control over the possible use of the long-range weapons to strike targets on the Russian soil, those Western states became involved in armed conflict. And actually, the question is it true from a legal perspective and from your research? Can we consider the intelligence sharing as a part of belligerency, or this intelligence sharing must always be concrete and direct, especially in this context of the use of long-range weapons that I started my question with?
Again, really interesting set of questions. And again, intelligence sharing is one of these types of assistance where it really depends on the scenario. So it's interesting that I think what we can glean from the statements by Russia and Western states that you have referred to is that actually they may not be that far apart from one another in terms of the legal, the abstract legal criteria that they would be applying. And they're rather debating the facts. So Russia seems to be saying, well, if it is the case, Russia seems to be saying that Western states are in effect conducting military operations against Ukraine. It is them who are effectively taking the decisions. It is almost as if they were themselves launching missiles at Russia. And if that were so, then there's reasonable grounds to argue that the criteria that I have proposed were fulfilled. And Western states are arguing, well, no, this is actually not what we're doing. But in effect, they're thereby also saying, well, this would be the threshold. So it's interesting that this kind of practice, these kinds of statements would actually confirm or at least hint towards those that line, those criteria that I have suggested. Now, how would I assess the situation? Well, I think intelligence sharing can make you a party to an armed conflict. And that would presuppose that the intelligence that you're providing is part of of a specific military operation, and specifically it can be part of the targeting cycle. So if you provide concrete coordinates of specific military targets as part of a concrete military operation, well, then that kind of target geolocalization and verification can actually be part of the targeting process, and as such part of a military operation, such that that would actually fulfill the criterion of a direct connection to hostilities. And the second criterion can also be fulfilled in such a circumstance, because sharing that degree of granular information will almost by necessity imply that you very closely coordinate your acts. And it may be the case, so if sort of the Russian account of the facts were correct, then Western states would be heavily involved in taking specific decisions on concrete military operations and on where and how to engage Russian targets. The difficulty with intelligence is that almost by nature, the exact circumstances as to how it's provided are not that well known to the public. So we don't know for sure. And Western states, I think, are not denying that they are providing certain intelligence, but they would probably disagree or deny that it is that granular, that they are taking part in the actual decision-making processes. And So this is, I think, what we where the sort of the difference is. It's one of what is actually true in terms of the facts, because regarding these long-range weapons, there are different views as to how they operate and what they require of the state that provides the weapon. What sort of information, what sort of intelligence you have to provide, how far you have to be involved. So there's some people who say, well, actually, with these long-range weapons, you actually almost have to operate them yourselves as a state providing them, which is sort of the argument of the German chancellor. He seems to be arguing, well, basically, it would mean German military personnel launching concrete operations at Russia. While there's lots of other military experts who say, well, no, that's actually not necessary, and you could train Ukrainians, and you don't have to be that closely involved in specific military operations. So again, I think that is where the dividing line is. And then regarding your point on restrictions being lifted, were restrictions actually some sort of control over the decision-making process? Well, I think that's true. If you say there is a restriction and you can't use that weapon with respect to targets on Russian soil, that gives you a degree of control over Ukraine's military operations, but those were not actually that was not actually control with respect to any specific concrete military operation, but rather sort of abstract control, and that is not what I would categorize as a direct connection to hostilities.
Yeah, thank you. It was actually kind of my follow-up question regarding the restrictions, because what you mentioned, that actually restriction means that we restrict something, so we actually have this ultimate control of the final use of the weapon. For instance, we could, I don't know, restrict the weapon in certain geographical area, and it happened in the past, because already in 2023, or actually at the beginning of 2024, when the Russians were attacking Kharkiv area, Biden said, you may attack Russians inside Russian territory, but only in the area of the Kharkiv, those forces which are preparing the offensive. So it means basically to me that from the operational perspective, that, okay, Ukrainian side need to deliver some kind of, I don't know, intelligence data and said to the other partners that, okay, we have the evidence, those units are located here, are you approving the attack or not? And this is the example of what you said, that this is the problematic question of control. So I was wondering whether from political perspective, maybe a little bit question of a political perspective, it is not smarter to set, this is Ukrainian weapon, Ukrainians are sole responsible of the use of the weapon, and it's their decision whether they would like to strike. They are exercising their right to self-defense. They're under armed aggression, and it's their decision. So as a maybe short follow-up, what do you think about this perspective, that maybe those restrictions are actually getting dangerously us to the edge, but maybe we just don't know enough details, because maybe those details, maybe it's just a mere approval whether the geographical requirements are met. What do you think about that?
Yeah, so I think it's a good thought, and certainly I'd say you're right that restrictions give you more control, and control obviously can have legal consequences that you may not have intended. But I don't think on this account that this kind of control that you have, the control that means you cannot attack in a certain area, or you can only attack on your own territory. I don't think that that kind of control is sufficient to constitute a direct connection to specific hostile acts. As you say, of course, it may have sort of ripple-on consequences regarding back and forth as to, well, can we attack here or there? Though I think if the line is it is on this and that territory that you may attack, that is something different from saying attack that target, because it gives you room to do something, and it prohibits you from doing politically prohibits you from doing other things. But I don't think it's a direct connection to facilities. I also don't think it's involvement in the decision-making process that would constitute sufficiently close coordination with respect to a specific military operation. That is always the crucial thing that we need to bear in mind. And one other thing that I think we should bear in mind with all this debate on restrictions on may Ukraine use Western weapons on Russian territory or not, we should say that from the perspective of legality, I think there's no issue, there's no concern. The concern is purely political, because obviously Ukraine has the right to defend itself, and to do that, it may do whatever it takes, which means everything that is necessary and proportionate to fend off the attack. And that obviously can also include conducting self-defense operations on Russian territory. So there is no sort of legal issue in principle with Ukraine using force on Russian soil. It's really a concern of escalation. We've seen that line shifting, as you said, right? At the outset, all Western states were reluctant to allow that to happen, and now an increasing number of Western states has lifted that restriction. So we see that political line moving somewhat further. It has never been, on this account, a line that was connected to party status, and it certainly is not a line that is connected to the legality of the action. And actually, if I may add perhaps a more general point that perhaps nicely fits in here, if I may, we should always keep in mind why all this matters. Why are we even asking the question of how do you become a party? What are the implications that flow from party status? And here, I think there's really some confusion that has been going on in political discourse for a while, because obviously it's not per se illegal to become a party. It's a political line. You may not want to become a party for political reasons, but whether or not it's legal or illegal depends on the use ad bellum. Have you got a right to use force under self-defense, in this case, or not? And Ukraine has that right to use force in self-defense against Russia. Russia doesn't have it. And Western states or other states may support Ukraine in Ukraine's individual right to self-defense and the exercise of that right. And they were even entitled to use force in collective self-defense against Russia because Ukraine has requested such assistance. Now they're not willing to do that, but they would be entitled to do so. And if they did, they would become a party by virtue of a direct connection to hostilities and close coordination. But that would not be illegal per se. And it would also not give Russia the right to attack Western states, because again, Russia has no right to self-defense, and there's no right to self-defense against self-defense exercised by Ukraine and potentially its partners. Now, that is not why it matters. Instead, party status matters because it means that the legal framework governing your actions, that framework changes. So you get a whole lot of IHL obligations that you wouldn't otherwise have regarding the conduct of hostilities, the protection of individuals, the different legal rules applying to individuals in terms of their targetability, their protection, potentially war crimes, look at the nexus assessment, also different legal rules in the relationship between parties and third states. So a whole lot turns on party status, but it's interestingly not that what people usually associate being a party and being at war, what they associate that with in legal terms. So there's a mismatch between the popular perception, the political discourse, and what that discourse sort of suggests the legal meaning of party status would be, and what it actually means.
Yeah, thank you very much for this general remark. And actually, we agree that the issue of the clear legal division between jus ad bellum and jus in bello is a very, very blurred question for the general public opinion. And because of that, the politicians actually are also using these discussions for their political aims. Also, you mentioned in your previous comment the question, those concerns over the escalation, the further escalation of the conflict. And actually, this issue is very much discussed right now in Poland, also with the extremely significant debate over the possibility of the Polish army to shut down the Russian missiles. Those missiles that first of all, in first scenario, are directly getting the Polish soil, and the second one, more complicated from the legal and political, especially political perspective, those missiles that are still within the Ukrainian airspace, and the question is whether the Polish army can destroy those Russian missiles that are still being within the Ukrainian territory, within the Ukrainian airspace. Because the question is, and here also we have to mention those political circumstances in Poland. The presidential elections are going to be held in the next year in May, and actually this question might become one of the most crucial ones in terms of the Polish foreign policy and the security issues, because actually, do you agree with those who are stating that shooting down the Russian missiles, especially those in the Ukrainian airspace, can trigger the international armed conflict between Poland and Russia? And actually, this question is also very significant from the point of view of Poland as a NATO member state, because in such situation in which Russians can, let's say, respond directly to the Polish actions of shooting down the Russian missiles, also the question is very important whether Poland is within the situation, or would be within a situation of a self-defense, and the NATO can, as an organization, use Article 5 of the NATO pact. So here, this very, very significant issue, and we would like to hear the voice from the outside, because actually in Poland we concentrate mostly on our experts and our politicians. So we would like to hear your comment on this very, very complicated question.
I mean, it really certainly is a politically very sensitive matter, and I wouldn't want to sort of comment on what is politically wise to do, and that is obviously a sovereign decision for Poland to take naturally, and one that is not lightly made, certainly. But purely in terms of legal analysis, I think yes, shooting down Russian missiles would, I think, make you a party to the armed conflict. It would certainly have a direct connection to hostilities. You would be directly causing harm to Russia. There is no question on the directness not being fulfilled. It's very clear, I think, and you would certainly also have to very closely coordinate that with Ukraine. If sort of Poland was acting totally on its own behalf, and there was no coordination with Ukraine, then there would be a separate international armed conflict between Poland and Russia. So it wouldn't make a huge difference in that respect, but probably it would rather happen very closely coordinated with Ukraine, such that Poland and Ukraine would actually be parties to the same armed conflict with Russia. But again, coming back to my earlier point, and you also stressed this quite rightly, I think, it would still be legal to do so. Because, as I said, Ukraine is being attacked and is therefore using its right to self-defense. Poland may use force in collective self-defense to assist Ukraine in fending off the attack, the armed attack by Russia that is still ongoing. And shooting down these missiles is certainly necessary, and it also seems proportionate. And these are, of course, complex questions that need to be assessed on a case-by-case basis. But with that sort of these limited facts that you have sort of outlined in the factual scenario, I think there's no reason prima facie to doubt that those criteria would be fulfilled, and that therefore Poland could lawfully exercise the right to collective self-defense here. So again, we see it would make the state a party, but that would not mean that the conduct would be illegal.
Yes, thank you very much for this comment. I think this is a very crucial remark that basically Poland is entitled to support Ukraine, even if this most grave form of armed assistance, and it would not be a violation of the jus ad bellum. So, as you also said, there is no self-defense towards self-defense. So, eventual response of the Russia would be actually the armed attack that maybe possibly trigger even Article 5 obligation. But to be honestly, I don't believe that anyone in NATO is supporting or even forcing that scenario. In my opinion, this is a rather more obvious situation, because I think it would have some kind of, cascade effect. Like, this is not this direct first use of situation of the use of force, but it's rather a consequence of using aggression, committing armed attack against a non-member state of the NATO, which actually have, let's say, some kind of continuation in this form. But this is of course a question from NATO framework. But as you mentioned, this is a separation. There is a separation between jus ad bellum and jus in bello. So whether the Polish actions are lawful under the jus ad bellum, it's a separate question from the jus in bellum. As you mentioned, jus in bellum kind of reset. We have this principle reset, I would say, the framework, because we have the principle of equality of belligerents. So which means that Russia is allowed to attack lawful military objectives in Poland. There is a lot of other questions that could arise from it, like prisoners of war, or even a new grounds for detention civilians, like we have this interment provisions in Geneva Conventions. So, for instance, what happened with the Polish citizens in Russia or Russian citizens in Poland, whether, for instance, the Polish or Russian authorities would have new grounds for detention. So, as you said, there is some kind of line, and this line has some kind of, this legal line has legal consequence. But here I would like maybe return a little bit to the politics, because some people would say, okay, so what that Poland is going to be a party of the international armed conflict? That a lot of people may say, okay, this is just, let's say, another red line that was already crossed from offensive missiles, F-16s, ATACMS, Storm Shadow, and other weapons. This is just another red line, and there is not going to be, let's say, significant aside legal consequence. How you can comment on that? Because I remember at the beginning of the 20th century, a lot of people and a lot of states believed that there actually is something called subjective theory of war, that the states are deciding what is war, which actually, from a perspective of the IHL, is very dangerous, because if one state is denying the state of war, as Vladimir Putin did at the beginning, call it a special military operation, it could create a lot of legal chaos, ambiguity, and it took a lot of effort to actually explain to people that actually it is not relevant what the politicians are saying. But still, I kind of believe that many people are still somehow referring to the subjective definition that, okay, they're saying, okay, let's not be too technical. I understand that from the perspective of international humanitarian law, this could be considered an international armed conflict, that there is no criterion of intensity. But for instance, we don't believe that Russia would respond in any meaningful way. So how you can respond to maybe to a critics of our podcast, those who are saying that this is not that very relevant, because we have this feeling that this is relevant, and what you said about the consequence of being a party of international armed conflict. So how you could somehow comment on that?
Yeah, I mean, as you said, there used to be a huge debate in international law on whether the concept of war was subjective or an objective one, meaning, is it up to the states to say when they are at war, and only then are they actually at war as a matter of law, or does it depend on the facts on the ground? And I totally agree with you that as international law stands today, that objective conception of war has pretty much won the day. So this is the prevailing notion. Both international and non-international armed conflicts are objective concepts. They're assessed based on a certain set of facts on the ground. Now, if you look a little bit more closely, then it's there are certain sort of remnants of subjectivity, if you will. One very perhaps the most obvious aspect, the most obvious remnant of subjectivity, if you will, is that the Geneva Conventions, Common Article 2, actually still refers to declarations of war. So that suggests that declarations of war are still possible. Declarations of war meaning, well, if you declare war on another state, that is sort of subjectively saying, well, I believe we are at war now, and therefore we are at war. And I actually think, and there are a handful of examples where that has happened since World War II, not very major ones, but it probably still is possible. If states want to declare war, well, probably they can. It's just that they very rarely do so. Now, interestingly, we sometimes see that that notion is still present in the sort of popular conscience and in public discourse when we look at how certain statements by politicians are assessed. So, for example, when the German foreign minister at some point said something along the lines of, we are fighting Russia, and then she corrected herself, but then everybody in the press was writing about how she had declared war on Russia. Now, obviously she hadn't, but it shows that that idea is still around, and I think it's not only around in popular parlance, but it's also still a theoretical possibility. Again, I don't think that this is what is happening here. I don't think any state has declared war on another in the war in Russia's war of aggression against Ukraine. I think that what matter here is the facts, and I don't think you can escape the facts, and this is important, right? There may be a subjective route to become a party, but there is no subjective route to escape the objective facts on the ground. So if Poland or Germany or any other state, by virtue of its actions, would become a party alongside Ukraine, it wouldn't matter whether that state or Russia or Ukraine actually wants the state to be a party or not. You can't sort of contract out of party status, even if all states agree that you're not a party, you can't. This is something that flows from the objective assessment of the facts on the ground, and you measure those facts to the criteria that I have suggested. At least that is my reading of international law as it stands. And again, perhaps to specify, to come back to what I earlier said, this sort of non-existence of a subjective dimension in party status, the fact that you can't escape party status by saying, well, I didn't intend to be a party, I don't want to be a party. That's something different from the subjective element that I was referring to that's required, namely knowing what you're doing. Knowing the facts of what you're doing is something different than intending the legal consequences.
Yeah, of course, we agree that this kind of fundamental question is whether how to not to escape the facts, and this is very, very important. One of the consequences of the war for Russia itself is to some extent the necessity for the Russian Federation to seek for the assistance in such countries like Iran or North Korea. We perfectly know that, especially in 2023 and 2024, the Russian Federation is using the Iranian drones, Shaheds, for instance, but the recent decisions of Vladimir Putin and Kim Jong-un, the leader of North Korea, forces us to actually set a question about the North Korean involvement in this armed conflict, because as we know that the North Korean military forces are being present in the Russian Federation on the Russian soil, especially in the Kursk Oblast, so very close to the Ukrainian border. But according to the recent data, North Koreans were not witnessed within the Ukrainian territory. Of course, the situation is very dynamic, so we have to also to set this limitations for this question. However, how do you assess those alleged activities of North Korean military in Ukraine? Whether the question is whether the North Korea actually became already a party to the international armed conflict on the side of Russia, or if not, what circumstances can lead us to this this kind of assessment that North Koreans can become a party to the international armed conflict observed in Ukraine between Russia and Ukraine?
So to my mind, there are reasonable grounds to believe that that North Korea has become a party to the war against Ukraine. Now, why is that so? Well, if we look at the criteria that I've proposed, clearly there is a direct connection to hostilities if North Koreans are fighting alongside Russia. So this is sort of the vanilla case of a direct connection to hostilities, if you will, fighting yourself with boots on the ground. No problem there. There's also no problem as regards the direct, the sort of close coordination between North Korea and Russia, because by definition, if you coordinate so closely that you effectively integrate each other's troops into your armed forces, or you literally fight alongside one another, that must be extremely close coordination of specific decision-making processes in concrete military operations. So the only problem really is it too close? Is it so close a coordination that actually they're part of one and the same party to the conflict? So the question here is, in a sense, at a sort of preliminary level, is it actually North Korea that is acting here? Are the acts of the individual North Korean soldiers and generals on the ground, are they attributable still to North Korea, or are they exclusively attributable to Russia? If they were exclusively attributable to Russia, then there would be no act by North Korea as a state, as a matter of international law. And if there was no act by North Korea as a matter of international law, well, then there would be nothing to which we could connect North Korea's party status. There wouldn't be anything that party status would flow from. And the North Korean soldiers would, as I said, simply be part of the Russian armed forces, full stop. Now, it's possible in theory, perhaps, for states to lend their organs to each other. Article 6 of the Articles on States' Responsibility foresees this possibility, but the standard set by the International Law Commission is quite high. It's exclusive control. The exclusive control must be held by the receiving state for the acts of the sort of the organ that you lend, in this case the armed forces that you supply, for these acts to be attributable only to the receiving state. Exclusive control for militaries, I mean, if it's at all possible, then it's probably not fulfilled here. Some people would say it's probably never possible for militaries to be that sort of cut off from their usual chain of command. And everything I have read, in fact, suggests that, of course, there are certain links that are being maintained between the North Korean soldiers and generals and Pyongyang. And as long as Russia's control is not exclusive, it may be the case that the acts of the North Koreans on the ground are attributable both to Russia and North Korea. We may have a situation of dual attribution. But dual attribution would still mean that both states would be parties and not only Russia. So this is, I think, the most plausible assessment. Again, it depends on the facts on the ground, but I think those facts give us reasonable ground to believe that North Korea is a party.
Yes, thank you very much also for this assessment, which is, as you said, might have legal consequence. For instance, the question of neutrality again came in, because if one party, one state is involved in armed conflict, here we have the opposite situation, because actually North Korean involvement would be unlawful per se, because this is participation in aggression. So on the other hand, what about the neutrality re-emerges somehow in terms of this aspect, that actually you have to be neutral in case if you wonder whether to help aggressor or not, that there is no let's say passive here, that actually there is no gate here to join the aggressive war, that actually international law is saying, no, you can't do it. You may help victim of aggression, but you cannot help the aggressor. And I think the North Korean and to some extent Iranian involvement is unlawful per se in this context. So I think unfortunately we are out of time, although we love also to discuss the developments in the Middle East, because just recently we observe unfortunately re-emerge hostilities in Syria. And your book and research is not only about international armed conflict, it's also about non-international conflict as well. And there are very interesting aspects of whether how you can become a party to non-international armed conflict when a state which is intervening in civil war is becoming a state of the armed conflict. And I guess the Syria is a unfortunately great example, because many armed groups are affiliated with Iran, with other states, with Turkey. Also, there is involvement of Russia, of the United States, and etc. But I guess this is for another episode. But here I would like to very, very much thank you for those assessment. I think you proved the point that it is very important to discuss it, not only from the perspective of politics, but also from perspective of international law. That, for instance, in this hot discussion going in Poland, that yes, we can support Ukraine, but it could have a consequence of being a party of international armed conflict. And despite our support is lawful, and despite we are not violating international law by supporting Ukraine, even in this most grave form of armed assistance, still there's this legal consequence of being a party, and you said there is no escape. So I guess this is a great summary of our talk. So here I would like to thank you once again for being a part of our podcast. As I said, you are actually a first guest, international guest, so we are very privileged and very honored that you were with us here today.
Thanks very much for having me. It was my pleasure.
Thank you very much. And our listeners, we count on your likes, on your subscriptions, and also consider a book of Dr. Wentker, Party Status to Armed Conflict in International Law. It's not only about international armed conflict, it's about armed conflicts at all. If you would like to explore the topic in depth. Thank you very much again, and see you on our next episode.